Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. I hope you guys are having an amazing Saturday. We got to get up and cook and clean and yell at kids and all this other stuff, but I had to take a break and say, let me do a couple of videos and then probably go fishing later on. But I wanted to talk to you guys about the Jussie Smollet'S conviction that was overturned. Last week, the Supreme Court of Illinois had a 5-0 and agreed to overturn Jussie Smollett's 2019 attack or conviction, where he came out and stated that two men attacked him. And when people go digging further enough, they find out the truth. So the truth was he paid $3,500. Now I don't know if it was to each person or to both of these individuals, but he paid them to pretty much assault him downtown Chicago. And they also yelled out, slurs, putting a noose around his neck, yelling out MAGA country. And, that really brought the country in an uproar. Okay. Because at that time, we was like, look, Donald Trump is president and everything was just, chaotic during his time in office. So I guess Jesse just, I don't know what he was thinking when he did that. I honestly don't. But he was charged. He was arrested. He was charged. However, he worked out a deal with the state's attorney in Cook County, and that he agreed pretty much to forfeit the $10,000 bond and to do community service. I'm about to say customer service, community service. For some reason, the state's attorney recused herself, and so and when I say they, the government or the state, said, okay, she recused herself, so that deal that y'all worked out is, not valid, it's void. And so they ended up actually charging him again and convicted him. And so that is what brings us to today. And this is what the Supreme Court of Illinois was reviewing and trying to determine whether or not that second prosecution was necessary. Okay, because remind you guys, he already worked out a deal. They said, and the state's attorney for Cook County stated, we will drop your charges in exchange that you forfeit your $10,000 bond and you perform customer service. I mean, community service. All right. Now, I'm going to get into the opinion. However, I am not going to read all of the opinion. I will just simply probably make a link in the description box below. And if you guys are nerds like myself, you can go read this 32-page document. But I want you guys to get a brief, um, idea of how and why the Supreme Court ruled the way that they did. So this opinion was filed on November 21st, and it stated that Justice Rockford delivered the judgment to the court with opinion. And we have Justices Neville, Overstreet, Holder, White, and O'Brien that concurred in the judgment and the opinion. From my understanding, it was a 5-0. So they was like, yes, we agree to get this overturned. It says that Chief Justice Thesis and Justice Cunningham took no part in this decision. So, just kind of going over, this is the reason as to why they got where they are right now. It states, today we resolve a question about the state's responsibility to honor the agreements it makes with defendants. Okay? Meaning, if the state has made a deal with the defendants, is that enough? Pretty much. Specifically, we address whether a dismissal of a case by nolle prosequi allows the state to bring a second prosecution when the dismissal has entered as part of an agreement with the defendant and the defendant has performed his part of the bargain. So the nolle prosequi, that is just like a entry of record that the prosecutor has decided to, abandon the lawsuit. Okay. So they'll abandon the lawsuit, they'll drop everything if you go ahead and you agree to do this. It says we hold that the second prosecution under these circumstances is due process violation, and we therefore reverse the defendant's conviction. And that's one thing that we was hollering during that time. Like isn't that double jeopardy? That's double jeopardy. That is double jeopardy. All right, so background. And like I said, I'm not going to read all this, just a few, so you guys can kind of get an idea of what happened. It says that a complete statement of facts may be found in the appellate courts of opinion. So obviously they had all the facts of the case. But what they did, they only set forth only the facts that was necessary for an understanding of the sole issue they decide. On March 8, 2019, a grand jury returned a 16-count indictment charging defendant Jussie Smollett with the felony disorderly conduct. The charges alleged that the defendant falsely reported to Chicago police officers that he had been a victim of a hate crime. 18 days later, on March 26, 2019, an assistant state's attorney explained in open court before Judge Stephen Watkins that the state was moving to no pros the charges. The assistant state's attorney explained the decision to the court as follows. Judge, on today's date, the state does have a motion in this case. After reviewing the facts and circumstances of the case, including Mr. Smollett's volunteer service in the community and agreement to forfeit his bond to the city of Chicago, the state's motion in regards to the indictment is to no pros. Pretty much drop, abandon, get rid of. We believe this outcome is a just disposition and appropriate resolution to this case. I do have an order directing the clerk of court, circuit court, to release bond payable to the city of Chicago to be sent directly to the city of Chicago Department of Law. And there's an address and the person there who takes care of that on behalf of the city. So the bond was $10,000. The trial court granted the state's motion to no pros and to release defendant's bond to the city of Chicago. On April 5th, 2019, a retired appellate court justice filed a pro se motion to appoint a special prosecutor in the matter of the people of the state of Illinois versus Jussie Smollett. The motion raised questions about the resolution of the charges and the manner in which the Cook County State's Attorney Kim Foxx had recused herself. So where there was a little bit of debacle that was going on. They were very, very upset that a deal was reached. And I'm not gonna lie, at that time when it happened, I was like, what, really? Because it was a lot of confusion. But then when it came out that dude actually lied, I was like, my first thing is like, you wasted valuable time of the officers, detectives, everybody that was working on your case. Like, why would you sit there and you lie about that? So they were in an uproar. So a retired appellate court justice filed a pro se motion to appoint a special prosecutor in that particular matter. After briefing and argument, Judge Michael Toman entered an order granting the appointment of a special prosecutor. In the order, Judge Toman reviewed the facts of the case and wrote that the disposition of the case by way of nolle prosequi had shocked officialdom as well as the community. Judge Truman noted that both then Mayor Rahm Emanuel and then President Donald Trump had issued statements condemning the resolution of the case. Judge Truman specifically found that negotiations on the disposition had dated back to February 26, 2019, when first Assistant State's Attorney Joseph Maggots wrote that the Cook County State's office attorney's office could offer diversion and restitution but would indict if something could not be worked out. So what they're saying is that prior to all of this, they already worked out an agreement. An agreement was worked out during that time. And if they could, well, let me take that back. They offered. That's the best thing to say. So they offered a deal. I'm gonna say it like that. They offered a deal, and if the defendant did not accept that deal, then they would formally indict him. On February 28, 2019, the chief of the criminal division told detectives that they could no longer investigate the crime and that she felt that the case would be settled with the defendant paying $10,000 in restitution and doing community service. Judge Tillman then addressed at length the circumstances surrounding Fox's recusal. Judge Tillman found that once Fox recused herself, appointment of a special prosecutor was required. Instead, Fox appointed her first assistant, Joseph Maggots, as the acting state's attorney for this matter. Judge Tillman found that Fox had appointed Maggots to an entity that did not exist because there is no legally cognizable office of acting state's attorney. So you know how, if something happened to the president and then the vice president will, be in that position, and then the speaker of the house will now be the vice president, then you have somebody that's in that, and they're like acting like an interim principal. If the principal suddenly disappears, then the not the vice president, the assistant principal is like the interim vice principal. They're not, the interim principal. They're not really the principal until they go formally through that process. So that's kind of what it is here. So Fox appointed this man to an office that really does not exist. You can't be an acting state's attorney. You have to go through the process. Judge Tillman noted that in the People versus Ward, that the court had held that if a case is not prosecuted by an attorney properly acting as an assistant state's attorney, the prosecution is void, and the cause should be remanded for prosecution by a proper prosecutor. Judge Tillman also cited cases where proceedings had been voided because the prosecutions by unlicensed attorneys. So pretty much whatever deal they worked out is now void because there wasn't a state's attorney, and the person that she appointed as the acting state's attorney, he didn't even go through the normal process. You actually have to be an acting attorney or state's attorney. Let's see where I am. Judge Tillman concluded that there were no duly elected state's attorney of Cook County when defendant was arrested, charged, indicted, or arraigned, and that there was no state's attorney in the courtroom when the nolle prosequi was entered. Accordingly, Judge Tillman determined that the appointment of a special prosecutor was mandated to conduct an independent investigation of the actions of any person or office involved in this particular case and to determine if reasonable grounds existed to further prosecute the defendant. Because remember, they're saying if there was no deal at the time, then he would, or acceptance of the deal, then he would be indicted. But the fight was there was no prosecutor at the time. So therefore, anything that was previously talked about is no longer on the table. Judge Tillman later appointed Dan Webb as special prosecutor. Following the office of the special prosecutor's investigation, a special grand jury indicted defendant on 6 counts of felony disorderly conduct. In an information release, which is part of the record, the OSP explained that reasonable grounds existed to further prosecute the defendant because he had planned and participated in a staged hate crime attack and thereafter made numerous false statements to Chicago police officers. The information release, the OSP also stated that it had determined that further prosecution of the defendant was in the interest of the justice for several reasons. So this is why they went proceeded with prosecution. First, the OSP relied on extensive nature of the false police reports and the resources expended by the Chicago Police Department to investigate them. I mean, they was really out here doing what they needed to do because obviously they didn't take hate crimes, seriously. Give me 1 second. Oh, my child called me. All right. Second, the OSP contended that the CCSAO's disposition of this case was not similar to how it had disposed of similar cases. The CCSAO had stated in a press release that the case was being resolved under the same criteria that would be available for any defendant with similar circumstances. The OSP sought documentary evidence that would back up this claim, and the CCSAO was unable to provide it. Third, the OSP disagreed with how the CCSAO resolved the Smollett case. The OSP stated that it had obtained evidence showing that the CCSAO believed that the case was strong at the time it obtained the 16-count indictment against defendant. However, just 3 weeks later, the CCSAO decided to resolve the charges under the following circumstances. So, pretty much, if we just look at the first part of this, the Cook County State's Attorney at the time felt that this was a strong case. This man made false reports. He used valuable time, he used and misused valuable time of the Chicago Police Department, right? And then all of a sudden, 3 weeks later, they decide to work out a deal with this. Now, this is the special prosecutor. So the special prosecutor had to relook at everything and say, okay, because you have done all of these things, you made false reports, you used the city of Chicago. Um, the first time around, they thought that this was a very, very strong case. 16 counts. 16 counts. So, yes, we're going to go ahead and we're going to move on with prosecuting you. But anywho's going into this is what the agreement was between the state's attorney. So she said, we're going to resolve this if you do the following. And this is what's going to happen. You'll get a complete dismissal of a 16-count felony indictment. Only punishment for Mr. Smollett was to perform 15 hours of community service. Mr. Smollett will be required to forfeit his $10,000 bond as restitution to the city of Chicago. And this is crazy. This says it is how they came up with that number. They said it's 10% of the $130,106.15 in police overtime paid that the city alleges it paid solely due to Mr. Smollett's false statements to police. He was not required. Well, let me see. It says not requiring that Mr. Smollett admit any guilt of his wrongdoing. even though he kept saying that he was innocent thereafter. Not requiring him to participate in program, which he was eligible to participate in, which will require a 1-year period of court's oversight of Mr. Smollett. And then the fourth reason the special prosecutor gave was that the CCSAO decision makers had been unable to identify any new evidence they learned of between indictment and the dismissal that changed their view of the strength of the case against defendant. Defendant Jussie Smollett and his attorney moved to dismiss the new indictment on double jeopardy grounds because it's like, okay, I've already worked out a deal. Why y'all trying to hit me again? He also moved to dismiss on the basis that the appointment of the special prosecutor was invalid. Now, the special prosecutor is the one who was hired by or appointed by Judge Tooman to kind of like go over, investigate the case, and see if he needs to be charged. Well, not charged, he needs to be prosecuted. The trial court denied both of those motions, both of Smollett's motions. So we're not going to dismiss on grounds of double jeopardy, and we're not going to dismiss that the special prosecutor was invalid. So I'm assuming Jussie either fired those attorneys and got new counsel, and that new counsel also moved to dismiss the indictment on the basis of the agreement that was reached with the Cook County Special Attorney's Office. Defendant argued that he had entered into a non-prosecution agreement with the CCSAO and that the agreement was executed and enforced. He further argued that the OSP was bound by agreement because the OSP had CCSAO are both agents of the state. Defendant performed his part of this agreement when he forfeited his monetary bond and satisfied prosecutors as to his performance of community service, and the state performed its end of the agreement when it dismissed the case against him. So he's like, why are y'all trying to charge me again for the same thing? And I've already worked it out. So that's as far as I'm going to go. So, in a nutshell, the Supreme Court did find that, you know, he worked out an agreement, and it was, let me see, how can I say that? It was accepted. It was accepted. There was no reason of prosecuting him a second time. That is why they ruled that a second prosecution under the same circumstances is a due process violation. That's why they reversed it. And that's what we was hollering. I was like, I know this man is crazy and he's already been canceled. I don't know if you can be uncanceled from this, because I've seen videos and interviews of him where he is still maintaining his innocence. Um, but honestly, I don't think that you can come back from this, to be honest. You lied in front of the world and had people out there like ready to go all in, because we don't, we don't play about hate crimes with our people. You know what I'm saying? But you did waste valuable time. But once you work out a deal, that's working out a deal, and the state has to stand by their word. And the judge of the Supreme Court, all five of them, just felt that a second prosecution was a violation of his due process. So the question I want to pose, since all of this, since that 2009 conviction has been overturned, and now he does not have this over his head, should he be uncanceled? Well, yeah, uncanceled. What do you think? You think that this is going to be a comeback? Like, how can you come back from this? I know that he has had a lot of supporters standing behind him, his Empire family and his own family. But how can you actually come back from this when you press these false charges and you hired these men, and these men actually testified and said that you hired them. How do you come back from that? But y'all tell me what y'all think about this overturned conviction in the comments below. Don't forget to like, share, and subscribe. I will drop this 32-page opinion from the Supreme Court of Illinois in the description box. Until then, y'all be blessed, and I'm out. Bye.